Today on #Lawyered, we dissect the Derek Chauvin trial that's rocking the nation right now. We're going to go through the witnesses, the strategy of both the state and the defense, and share our opinions about how the case turned out. Welcome back to #Lawyered, everybody, and today we've got a pretty serious topic we're going to talk about, and one that really makes a lot of sense. We haven't gotten the opportunity to really dissect a case before, or a trial, since we started this show.
Yes, that's true. And I think that this one is a really heavy hitter to start with.
For sure. Might as well jump into the deep end, right?
Yeah, this is like the diving section and not even the deep end.
Right, that's a good point.
Yeah.
We're on the high dive here.
Yeah, we are.
Well, I think everybody knows, and we'll jump right into it because we've got a lot of material to cover, but the Derek Chauvin trial ended last week. And it came out, we've got a guilty conviction on 3 different counts, still waiting sentencing. We'll go through all that here in a little bit. I think that everybody understands the background story, but
yes,
just in case, Derek Chauvin was a Minneapolis police officer. He was involved in the homicide of George Floyd in 2020, which is obviously largely attributed to a lot of things that have to do with the Black Lives Matter movement, the riots and protests that occurred in Minneapolis and across the country.
Across the world, really. Across
the world. No, you're right. You're right. And I do want to be clear when I say homicide, I know we understand legal definitions, and the word homicide just means someone died and it wasn't a suicide. That doesn't mean, we'll get into all the details of the...
Yeah, homicide does not equate murder.
Correct. That's the best way to put it.
And I think a lot of people have that mistaken understanding.
Right. So you've got different variations of homicide, whether you go in Texas from intentional murder, which is like first-degree murder and capital murder, down to manslaughter, criminally negligent homicide, all those types of things.
And then as we'll get into it, I mean, it's even more specific in Minnesota than it is in Texas. So, and we'll get into that later, but that's really important for everyone to understand, I think.
And this is out of character for me because I'm not much on disclaimers, as you know.
I'm usually the disclaimer queen.
I know. I'm kind of more the shoot from the hip guy. But, one of the things I wanted to tell everybody is the trial transcript itself is not freely available right now. You can't just go grab that. That's something that, as you know,
it takes a long time to prepare, especially when you have a case like this. And there was at least 45 witnesses for the state alone, not even including the defense witnesses.
Right.
That's a substantial number of people.
Yeah. Well, it's 45 witnesses total. So
total. So
30,
including the state.
And 38 on the state, 7 on the defense side. But the trial transcript's not available. So sitting here today, we have not reviewed that. We haven't gone through and looked at every single question asked, every objection laid. We haven't done all that. And we're not journalists. So, what we do here is we try to go off of what we think are some of the best sources and review those, vet those, and then go through and give our opinions, because that's why we're a podcast. And so,
give our opinions based on what we think the law is.
Right. So the only reason I throw all that out there is just so that people know that, look, there may be some more specific technical details that we don't get to in this show because we just haven't had the opportunity to see every single line that comes into it. But I do feel like the sources we use and the information we gathered is reliable. And I think that our opinions, or what comes from it, is really going to be based more on our knowledge and experience than it is on, the actual specifics of the case.
Absolutely.
Well, maybe I should put that better. Based on the actual words used by each lawyer and the actual tactics in every single aspect of the case.
Yes.
Yeah. So we'll start off with this. Chauvin was charged with 3 different forms of what I'll call homicide, and it's different variations of it. When he was initially arrested, and Matt's going to throw the indictment up on the screen for our viewers once we get to this point, but he was initially charged with 3rd-degree murder and 2nd-degree manslaughter. And keep in mind, these are Minnesota statutes. They're very different than the way we have the law in Texas.
Yeah, we don't have these in Texas.
We don't. Ours is classified. And actually, let's just talk about that briefly. In Texas, you've got 3 degrees of felonies. 1st degree is the most serious, ranging down to 3rd degree. And then you have capital offenses, which are another form of murder. And so, 1st degree murder is intentionally and knowingly killing somebody. And so what's the difference between that and, say, manslaughter?
Sure. So, intentionally, knowingly killing someone, it has a premeditation element. It's like you go, you plan, you get a shotgun, and you shoot them, planning to shoot them. And so with manslaughter, you could be drunk driving your car and hit a child and kill the child, and that'll be manslaughter. You didn't intend to do it, but you were so reckless by imbibing alcohol and getting in a car, then you knew it was a reasonable well, we won't go into reasonable probability anyway.
Right.
The child died.
Yeah. Well, and so it has to, like you were saying, it has to do with your state of mind.
Absolutely.
Your mens rea, like we talk about in law.
Wow, throwing out Latin. Usually that's what I do.
I know. We're kind of flipping roles here. I'm doing disclaimers and Latin today. But yeah, so there's a distinction between intending to hurt and kill somebody or not intending to do that, making a reckless mistake. And then we also have what's called criminally negligent homicide, which means maybe you weren't as reckless as getting drunk behind a wheel, but you made such a grave mistake that was really like an unreasonable risk, which led to someone's death. And so that's going to be, less serious. So in Texas, we keep it pretty general when it comes to that. And then in Minnesota, that was one of the most surprising things to me when we started looking at this case is how specific and detailed the descriptions of these different homicides are. And so, like we try to do on this show, I'm going to use some of the actual text from the statute. And so, third-degree murder is governed by Minnesota Statute 609.195A, and it is causing another's death without the intent to kill, but evidencing a depraved mind without regard for human life.
I think that's really important to note that, again, not only is Minnesota law different than Texas law, right? But this is third-degree murder. So this is not what people think of as first-degree murder, which is going and intentionally shooting someone or knifing them to death. And so I think that's just important to keep in mind that this is third-degree murder. It's all awful. It's all terrible. But the difference is important.
Absolutely. And I think that was something you and I were speaking about, before we went on the air, is that the state did not charge Chauvin with the intent that he went out intending to kill George Floyd.
And I think that was a very mindful decision on the state's part.
Definitely.
I think they knew what evidence they had and what they could do with that. And so I think that was a smart move to make their accusations based on what the evidence was that they had.
Right. And I think that that's a distinction we really want to make important to our listeners, because of the fact that there's a big difference between this statute saying that he acted without the intent, or the accusation that he acted without the intent, versus saying he intended to kill George Floyd. I think that message has been lost a little bit in some of the hype.
I would say so. I think that, look, I love social media. My husband, not so much, but I like it. But I do agree with Spencer on the point that I think social media oftentimes can become an echo chamber. And it's difficult, not impossible, but it is definitely difficult to engage in a substantive conversation on social media that takes into account, to the relevant degree necessary, the appropriate details.
Absolutely.
And so a lot of people, and again, horrible, tragic, horrific, no excuses whatsoever. The evidence wasn't there that he went out and intended to kill George Floyd, right? But he acted in such a way that it was murder. It just wasn't first-degree murder. Yeah. And so, again, I applaud the state for choosing carefully the charges that they brought against him. Yeah. And clearly it was successful.
Right.
Because I think more often than not throughout modern history, we see when you have a seminal trial like this, you'll see charges that are brought. And sometimes those charges, they might fit what people feel is just and moral, but they don't fit the actual evidence provided.
Right.
And so I think the state did a really good job here providing charges based on what the evidence were, instead of trying to make a statement, if you will.
Yeah. No, I agree wholeheartedly with what you said, because I think, and this is what bothers me somewhat about our profession. You know me well enough to know I'm an idealist. And so in my mind, that's why I don't think judges should be elected. That's why I think that the district attorney should be insulated from things like charging people because it's a public seminal trial with things that the public wants them to charge them with versus what the defendant should be charged with based on what actually occurred. And so I agree with you. It is helpful, promising. I don't know what you want to call it. I like the fact that they took the crime, actually looked at what happened, and then charged it appropriately. That's what justice is supposed to be about, is let's figure out, did this really happen, and put that before a jury.
At the end of the day, people's trials should be in a court of law, not in a court of public opinion.
Right.
And I think the state did a great job of making sure that this trial did take place in a court of law. And didn't rely on the court of public opinion.
Yeah.
And look, they succeeded. The state succeeded. And I think it was better that the state succeeded on all of these counts, right? That these charges that were based on the evidence, instead of bringing forward, say, a first-degree murder charge and then losing on it, potentially, because maybe they didn't have the evidence for it.
Right.
Because then I understand the need to make a statement about how this is horrific and tragic and should never happen. I understand that. But what statement are you making if you bring these charges that don't have evidence to support it and then you lose?
That, and then also, is that really justice if you're trying to not follow the law and apply the law the way it's supposed to be and designed to be applied by the legislature in every situation that comes up? You know, if you're,
as a lawyer, no, I don't think so. But I understand how in the court of public opinion, it can get lost because these are technical things that a lot of people, their eyes glaze over and they don't want to hear about.
Right.
And anyway, so at the end of the day, I commend the state for their choice of charges that they brought.
Well, and going back to your point about not being able to meet the specific requirements of a certain statute like intentional murder, that's part of the reason the second charge came up, and it's second-degree manslaughter. And we're going to compare these two just because I think this concept is important for people to understand. Second-degree manslaughter is that Chauvin caused the death of Floyd by culpable negligence, creating an unreasonable risk, and taking a chance of causing death or great bodily harm to Floyd. Minnesota Statute 609.2051. Now, what's important here is I call that a lesser included offense. Now, what that means is that you can charge somebody with, in this situation, we'll take this example, third degree murder means that the state has to prove that Chauvin, without the intent to kill, evidenced the depraved mind without regard for human life. Well, under Minnesota law, I had to look this up because it's a term we don't use in Texas. Yeah. But depraved mind means that the act that the person committed caused the death is so reckless and dangerous that the person should be charged with murder if the victim dies from this act. And so, obviously, in this situation, we're saying that the act of him placing his knee on his neck was so reckless and dangerous
for the amount of time that he did.
For the amount of the entire set of circumstances, so reckless and dangerous that you should have known that you could have caused the death, and that you kind of disregarded that risk. I mean, that's the heightened standard of the depraved mind situation. And there's an example of this in Minnesota. Actually, in Minnesota, violently driving an automobile, maybe even drunk, can be depraved mind, third degree murder. An accidental gun discharge while in a fight, or and there's one case that actually has been talked about next to the Chauvin case. It was the 2019 conviction of Muhammad Noor, police officer, got 12 and a half years in prison for shooting a woman while responding to a 911 call. And from the brief synopsis I read, basically he was in the passenger seat, woman calls 911, she's on the driver's side next to her partner, and I guess she raises her hands while she's talking to the police, and he reaches in, grabs his gun, shoots across his partner, and kills her. And so the act in that case, and this is still up on appeal right now, case was just, the conviction was just in 2019. Recent, yes. But the act in that situation, the jury found that act was so reckless that it indicated a depraved mind. Well, and the maximum sentence with that charge is would be 25 years. And so second-degree manslaughter is a lesser included offense because in second-degree manslaughter, you don't have to prove the depraved mind. You don't have to prove how the intense recklessness that occurred there. You just have to prove that the person was negligent to a degree that was still dangerous. And that sounds like we're splitting hairs there, but I'm sure. But reckless, as we know, the standard of recklessness versus negligence is different.
It's pretty substantially different.
And so the idea is that the state says, okay, well, look, we believe that he acted with a depraved mind, but if we can't put forth enough evidence to convince the jury that he acted with a depraved mind, we're going to also charge him with this lesser included offense to say that he was at least culpably negligent. Therefore, he should still be convicted of that. And so it's part of the whole idea of double jeopardy where you can't charge somebody with murder. You get a not guilty verdict, come back and then charge them next year with second degree manslaughter, because we set up our Constitution that way to where that won't happen. And so the state's got to throw everything in there at the same time. Now, what's interesting here, and this is going to kind of be our segue into some of the pretrial setup, is that the district attorney charged and indicted Chauvin on those two charges. On May 31st, the ACLU Minnesota chapter petitioned the governor to have the Attorney General take over the case because they were concerned that if we don't get, if we don't end up having the conviction on these two charges, we'd like a third charge brought, which is the second-degree unintentional murder, which what we call the felony murder rule in Texas. And actually, I misquoted that. They were concerned that Chauvin was not being charged with second-degree unintentional murder, which actually carries the maximum sentence of 40 years, the most serious of the charges that he was facing. So after the ACLU brings that up, the governor appoints the attorney general to replace the district attorney. Now, that also happened because the defense filed a motion to disqualify the DA from the case. Now, why do you think they did that?
Really? Really? Why do I think they did that? Why don't you just tell me why they did that?
I mean, I think that they probably did that because they believed that an elected official in the city where the crime occurred was going to be too prejudiced to go in and actually try the case unbiased, and he was going to be swayed by the public opinion. Which is interesting, right? Because when you have protests literally sparked all around the world by this atrocity, I don't really think there's any way to avoid any bias, if you will, in pretty much any person who saw this, or any person that, well, I won't go too far into that. But anyway, I don't think a motion to transfer venue or a motion to disqualify the district attorney would have done much in that mindset. And we're definitely going to get into some of that during the discussions about the appeal and all that kind of stuff. Okay, we've got three charges: second-degree unintentional murder, second-degree manslaughter, and third-degree murder, depraved mind murder, as they call it in Minnesota. And as we go into this, Judge Peter Cahill, the Hennepin County judge, is overseeing this trial. We've got a team of prosecutors led by the Attorney General, and then we've got defense lawyer Eric Nelson to kind of set the stage here. Just one? Well, he had a team, but he's the guy that everybody's been quoting, and he's the one that's got the camera time. We'll put it that way. Sure. So within this, so you just talked about this, Hennepin County, it's where Minneapolis is, where the arrest occurred. It's where the trial took place. There was a motion to transfer venue filed by the defense, and so typically, why would you, in a criminal case, as a defense lawyer, why would you file a motion to transfer venue? Well, you're going to do that because you think that the jury pool is so tainted that you're not going to be able to create a jury that actually is willing and able to listen to the facts of the case without being subject to their own internal bias or the information that they have heard. Right. And so they can't actually do what a juror is supposed to do, which is just listen to the facts of the case as they're presented in the courtroom, and then make a decision based on the instructions given to them by the judge at the end of the day on the jury charge. Yeah, and I think the O.J. Simpson trial, highly publicized. Definitely a great example of that. Yeah, and so there was a big fight about the venue prior to. They ended up trying it in downtown L.A., and there was a lot of controversy about that because of all the racial. There was a lot of controversy, and if I recall correctly, they wanted to try and transfer the case to, I think, wasn't it where OJ lived? I believe so. What was it? Brentwood? Well, he lived in Brentwood. I don't know what county that was or what. That should be LA County. But anyway, I think they wanted to transfer the case. And so if I'm operating off memory here. Yeah. And the issue there was that, if I recall correctly, the jury was predominantly white, wealthy, and very privileged. Yeah. Which would have worked in his favor. Yeah. Yeah. Well, and so that's a great example of the way that went down. Here, there were a couple of things at play other than just the publicity. The publicity, to me, the publicity was the biggest part. But on top of that, right in the middle of jury selection, George Floyd's family had sued the city of Minneapolis. Oh yes, I do remember that. Yeah, they sued the city of Minneapolis and then settled for $27 million. It's a substantial amount. Yeah. Of course, human life is priceless. But $27 million is a substantial amount. It's a substantial amount, and we're going to get into this more detail here in a second, but it's also, if you think about when Floyd's death occurred, and then this settlement comes out, you and I both know the life cycle of a lawsuit, especially one of that magnitude. It's a little insane that it came that quickly. It frankly does blow my mind. And actually, instead of waiting till later, we'll just talk about it now. With the criminal trial, I have some guesses as to why, but I still can't believe, we talked about this in my office, his death occurred last year in, I believe it was May of last year. We're in trial in starting in March of this year.
Less than a year.
For a trial of this magnitude, with a murder trial. I mean, I've had DWI cases that have gone 2.5 years before going to trial.
I have breach of contract cases that are still waiting on going to trial, and it's been 2 years.
Yeah. So it's a little insane that was how quickly this case got to trial. And my speculation is that the city was like, we need to
keep it moving.
Yeah.
This is, I'm sure and I don't want to sound trite, but I'm sure it's, a political nightmare for the city.
Yeah.
For this to have happened and for everyone to associate Minneapolis with this thing that occurred.
Right. It kind of reminded me a little bit, just the timing aspect of it kind of reminded me a little bit of the trial of Saran, the killer of Bobby Kennedy. It seemed like that trial got to court real quickly. And it was because coming off the tail end of his brother's death, it was like the country wanted to get this over with. And that's honestly what this felt like a little bit here.
I'm sure the whole world wanted to see a conclusion to what had happened.
Yeah. And so the criminal trial gets to trial very quickly. The civil settlement happens very quickly. And it actually happens in the middle of jury selection. And the defense lawyer says, we want a motion for continuance. We want to transfer the venue, because essentially the argument was my client's boss, the city, the police have paid over a settlement and basically spoken to the public, including our jury pool, that, we think that we were civilly liable for what happened.
And so let's back this up for a moment. So during jury selection, at least in Texas, right, the jury, when they are actually selected and impaneled, right, and so when I say impaneled, they're actually like, okay, y'all, the jury, you've got your one or two alternates in the backup, you are in the jury box, so impaneled, right, because the panels of wood that create the jury box. Yeah. That is when they receive the instruction that they're not supposed to essentially listen to the news, listen to other facts about this case, discuss the case, so on and so forth. That's when they're insulated, if you will, from the facts of the world. So if anyone ever watched the FX miniseries People versus O.J. Simpson, there's a scene in there where the jury is taken to a hotel, but all the TVs are removed from the hotel, all the newspapers and magazines are gone, and it's just old books or old magazines prior to the Simpson trial. Yeah. And that's so that the jury isn't tainted by evidence, right, or information about the trial that would taint their understanding of the evidence being provided to them in a courtroom. Yeah. And so here, right, this is during jury selection when that settlement occurs. The jury has not been impaneled, which means they don't receive that instruction, which means they're hearing all of this, which is going to fundamentally, arguably, alter how they view and hear the evidence that's presented at trial.
Yeah. And so 2 points I want to make on that. One's from both from a defense lawyer's perspective. The first one is that jeopardy doesn't attach until the jury is impaneled, like you were just talking about. And
at least in Texas.
Right. Well, and I think
everywhere.
I think it's everywhere.
I am only barred in Texas, so I think everywhere.
So the reason that's important here is, okay, during jury selection, you can stop the trial and start it over another time, and you're not going to impair the state's ability to continue to prosecute Chauvin at that point. Yeah. Now, once the jury is impaneled, then at that point, okay, the trial's got to go forward, and unless there's a mistrial, the state's got to proceed on what it has.
Which is a high bar. Mistrial is a very high bar.
And so the thing that's important about that is, if the court was concerned at all that this was going to taint the jury pool, they had an opportunity to do that without disrupting the entire case too much. I mean, it wouldn't have thrown the huge wrench into the gear well, but it just would have kind of delayed some things. The other part is that, unlike the O.J. Simpson trial, this jury was not sequestered. And so, in O.J. Simpson, just like you were talking about, they were actually forced to go stay in a hotel, forced to not talk to anybody, and all that kind of stuff. Here, they were sequestered during deliberations, which occur after the trial is over, when they're thinking about what they're going to render their verdict as.
But during the trial, they were able to go home.
They were to go home. They were told.
We're using air quotes here.
Yeah, told not to look at the media, not to read things.
Well, I'm sure they were told that, but did they actually do that?
And that's my point.
People are human.
Right. And so, who knows? I mean, and then
maybe they didn't.
We're going to talk about appellate grounds later, but that's one of those things that, I mean, who knows if they did or didn't, but the opportunity, the temptation, all those types of things. I mean, that was the reason the defense filed this motion, on top of the fact that the settlement came down. Judge Cahill was quoted saying that, this is going off of something that you said a moment ago, I do not think there's any place in Minnesota that would give the defendant more of a fair trial beyond what we are doing here today. And when he says what we're doing here today, they had done a lot of pre-trial planning prior to the jury selection pool ever being put together to put out questionnaires in Minneapolis, try to assess how biased and how tainted they thought the pool would be, which makes sense, but I think can only go so far. So I think that, well, we'll get into that later. Additionally, outside the courtroom, the Minnesota governor, Governor Walz, commented on the case until the judge asked him to stop doing this because of the political
blows
influence.
my mind, because frankly, at the end of the day, that was, and I'm sure this is an unpopular opinion, that's extremely inappropriate for the lead executive official for the state of Minnesota to make commentary on the trial as it's going on.
Yeah.
I understand that he wants to take a stand against systemic racism. I get that. But at the end of the day, you need to let the justice system do its work. And there is time for you, once the justice system has done its work and you are no longer potentially impairing it by possibly tainting the jury pool to the degree that a mistrial is caused, which means we might have to completely do everything over again, which no one wants, especially since the results that were achieved were the ones that were achieved. Yeah. So I just think it's very inappropriate that the governor did that. Yeah.
I'll give you a counterpoint. I agree with what you're saying, but the counterpoint, I think, would be, okay, the governor is a part of the executive branch. The district attorney is part of the executive branch. And so, the DA is going to say what he's going to say in a microphone. Maybe the governor is just an extension of that. I'm just throwing the counterpoint out there. Sure. I agree with what you're saying because it's a different position that you're in. You're the DA, you're directly charging somebody. As a governor, you just want your system to function the way it's supposed to function. So let's jump into the trial itself. State versus defense strategy. The state, it was very clear what they were doing. They, as I put it, they used cumulative witnesses. They had 38 witnesses.
Substantial.
And they had two major issues. One, show that asphyxiation or lack of oxygen was the cause of death, and that the use of force was unreasonable. And they really stacked their witnesses on those two issues. They had numerous fact witnesses, including the very first witness they had, I believe was one of the first couple was Darnella Frazier, and she's the person who actually filmed the famous video that has been going viral. And obviously that video, I mean, if I was the state, I would have led with that because it just locks the jury in. That's what honestly, that's what they've been looking at. So that's what they want to see. Seen
since this occurred.
Yeah. And then, I took down a lot of information about the different witnesses. I'm not going to roll through everything they said, but speaking specifically to the asphyxiation point, because that was a key point between the defense and state, and we'll get into the defense strategy in a second. The state's major witnesses were a Dr. Martin Tobin. He's a physician in pulmonology, which I've learned has to do with your lungs and your heart and interaction between it. And he testified that Floyd died because his lungs could not get enough air, and the low level of oxygen is what suffocated him. And the state then brought in numerous forensic witnesses to back up what Dr. Tobin said, and really focused in on lack of air, which makes sense with the entire theme of, okay, you closed off his neck way, he couldn't breathe, and that was the cause of death. And so, on top of that, let me pull down here, the interesting part was that the state's chief medical examiner, and actually what's funny is my girlfriend Rachel and I, she brought this up and we started talking about it because you wouldn't have expected this because the state's whole theme was asphyxiation, but the state's chief medical examiner, Dr. Andrew Baker, said that his cause of death when he did the autopsy and did the study was caused by cardiopulmonary arrest, which means he's saying this tied Floyd's severe underlying heart disease, his enlarged heart, which needed more oxygen, combined with the stress of the situation, which eventually led to things like his adrenaline spiking, his stress hormones pouring out into his body, and it's going to force your heart to beat faster, and it's going to need more oxygen. So he, at the time, did not state in his report, when he did the report way back when, that asphyxiation was the cause of death. And so the defense obviously keyed in on that.
Of course, and they had to, right? Because what other options available to them? Nothing.
Right.
It's the only option they had to try to mitigate the charge, not mitigate the charges, but mitigate the situation against the defendant.
Right, absolutely.
And so, and I think a lot of people are appalled by the fact that the defense would go and make this strategy, because they'll say, like, look, Mr. Floyd said he can't breathe a number of times.
Yeah.
And so I think a lot of people are pretty horrified by that. But at the end of the day, I see what the defense was going with it, and they were basing this off of, Dr.
So first the medical examiner, Dr.
Off the medical examiner's
Dr.
report.
Baker. Right,
yeah.
right, exactly. Because that's, just for big picture purposes, that's a great point, Andrea. That report comes out after George Floyd's death a long time ago. And so when the defense sees this and they're preparing for the case, they're thinking, okay, here's a strategy. Okay, we've already got the chief medical examiner saying that it wasn't asphyxiation. That's what we need to run with. That's going to potentially poke reasonable doubt into the fact that Chauvin caused the death of George Floyd.
And so this is important, right? Because, and step in, you're the criminal defense attorney here, but it's important, right? Because they're trying to cause reasonable doubt as to, okay, so the lack of air in of itself didn't cause it, and is it reasonable to think that a person who didn't have the underlying medical conditions that Mr. Floyd had in that same or similar situation, would he or she have survived? And is it a result of all of the underlying factors on top of the asphyxiation by the knee to the neck that caused the death? So is it solely Chauvin's fault that this happened, or is it all of these conditions? And so because of the language in that report, the state keyed in on that to try and make this argument that there are multiple factors. It's not clear that it's just the knee on the neck that caused his death, which, again, and I can understand how appalling that is for people, but from a legal technical standpoint, it's one of the few options the defense had available.
Right. And that's so, and you keyed in on that correctly. I mean, that's exactly perfect, because that's what the defense was trying to say is their strategy was that the force used was reasonable and the cause of death was drugs and a heart condition. And the state, and here, I mean, I'll share my overall opinion. I think that the defense lawyers got outgunned in this case. I think, in my actual opinion, looking at all this and really analyzing it, I think the defense lawyers did a marginal job of being prepared for how many witnesses the state was going to bring out there. And I mean, you just look at the 38-7, 38 state witnesses versus 7. That by itself is not as important, but the fact that the state came in, they got Dr. Chauvin coming in and saying asphyxiation was the problem. They back him up with multiple forensic witnesses that say the drugs were not the problem. They went through his DNA, they went through his blood, talked about toxicology levels, and really went through, because that was a lot of what the defense was saying is, look, he's high, he's got a heart condition, he's stressed out, fine, but all these things played into what happened.
All these things together caused enough reasonable doubt that to poke a hole in the argument, about the intent that Chauvin had, or the mental state, if you will, not the intent, the mental state. Right.
And the condition that his heart was going to be in because of all these things. Well, the state, it's like, I mean, they really did a great job with foresight of saying that's what the strategy is going to be. We're going to come in and rebut preemptively, because the state goes first,
Which is, I applaud the state on that, because sometimes it can be difficult to preemptively rebut. But if you can, that's a smart move.
So they bring in all these forensic people. I mean, I think there was 4 or 5 different forensic witnesses
Which
that
is
came
a lot.
in. It's a whole lot. And it went from paramedics to actual forensic experts coming in saying the fentanyl levels and the methamphetamine levels in his blood would not have contributed to this. They would not have caused X, Y, and Z. So they back up Dr. Tobin's testimony with that. And then they bolster they tie it all together. Their medical examiner who says it's a cardiopulmonary problem. They bring in Dr. Jonathan Rich, cardiologist at Northwestern Mutual, one of their last witnesses to talk about the medical side. He comes in and ties the whole thing together. He testifies that Floyd did die from the cardiopulmonary arrest caused by low oxygen levels, and those low oxygen levels were induced by the prone restraint and positional asphyxiation, which is the position that he was in, that he was subjected to by Chauvin. So the state saw the issues, tied it all together, and then boom, laid that out there. And then on the second point, and I won't belabor this too much because we've talked so much about this, but the state's other part, they brought in to talk about the reasonable use of force. They brought in the police lieutenant, Zimmerman, that says he testified that Floyd was subdued and the force used by Chauvin was no longer necessary. They brought in the police chief, Medaria Arredondo, and the chief went through and talked about the fact that there's an initial reasonableness of trying to use some of those maneuvers to get him subdued in the first few seconds. But after that, the I want to use the actual words here. Mr. Floyd was no longer responsive and even motionless to continue to apply that level of force to a person proned out, handcuffed behind their back, that in no way or shape or form is anything, in no way, shape or form is that anything that is by policy with the department. On top of that, they brought in Inspector Katie Blackwell. She comes in and talks about, she was part of who trained and knew Chauvin for about 20 years, that I don't know what kind of improvised position this is that he's using. It's not something we train in the police force. And then their final person on the use of force was an actual use of force expert, Sergeant Jody Steiger, former LAPD officer, 28 years, and goes on to say that basically just bolsters everything they said. Once he is subdued, this position no longer needed to be used. And so the state's idea was, let's just stack the deck with as many people that know what they're talking about with expertise in this situation and just lay this all out there before the defense even gets a chance to come out and talk about it. You know, the problem was after the state just pours it on, the defense comes back and they have their use of force expert is Barry Broad. He comes in and testifies that the prone control position, which is the position of pressing someone down and using your knee over their neck, is not inherently a use of force because it was unlikely to cause pain, which is a tough argument to make there, right? I mean, it's especially with even just looking at the factual video, right? You know, of him yelling out, and it's very clear he is in pain, no matter what kind of mental state he's in.
I mean, I understand experts. People have a hard time trusting experts a lot of the time, unless it's in a very technical field like aviation or a mechanical situation, because there is this concept that experts are paid to say what you want them to say, which they shouldn't be. They should be giving their expert opinion based on their education and the facts presented to them. But in this situation, I think it's probably hard to believe that that's what the defense's use of force expert was doing.
Well, and think about the defense has one use of force expert and the state has 6. I mean,
which is wild.
And the defense knows this going into it. They know the witness list. They know who's going to be called. They know all those types of things. The biggest folly to me from the defense side is that to counteract the asphyxiation argument, they brought in Dr. David Fowler, former Maryland chief medical examiner, 2002 to 2019. He testified that the primary cause of Floyd's death was a sudden heart rhythm disturbance occurred during his restraint due to drug use and carbon monoxide poisoning because he was next to the tailpipe
of one of the cars.
Which I did see some commentary. It's like, well, who put him next to the tailpipe? That's not helpful.
That is not a helpful situation.
Well, here's the problem too: is that after he testifies, puts his opinion out there, a letter comes in to the Attorney General's office, to the governor of Maryland and the Attorney General's office in Maryland, where Dr. Fowler used to be the chief medical examiner. DC's former chief medical examiner sends this letter signed by 431 doctors from across the country saying Fowler's conclusions were so far outside the bounds of accepted forensic practice that all his previous work as the chief medical examiner should be investigated.
That is different.
And that's the defense's star witness for this case.
I did not know that, and that is never a good sign.
And it's not that the jury knew that because this happened after the fact.
Sure, but my gosh.
If it was that bad, I mean, and that's actually prompted the governor and the attorney general. They are now opening an investigation into all of his previous work as the chief medical examiner in Maryland. So, in my opinion, I mean, we know after this, the jury convicts him. He gets found guilty on all 3 counts. And now he's going to be sentenced based on the most serious count, which is the second-degree manslaughter, second-degree unintentional murder. So he's maximum facing 40 years in prison. Sentencing guidelines say he'll probably get 15. And, one thing that our listeners should know, in Minnesota, it's similar to a lot of states. If you're charged on multiple felony offenses, you get sentenced on the most serious one if it comes out of the same criminal episodes.
The same set of facts.
Same set of facts, yeah. So that's why he's only going to be he's only going to be sentenced for the one, basically. And so kind of to close the loop on this, he's going to appeal this. I mean, it's all big trials like this get appealed for the most part if there's a guilty verdict. And I think the venue transfer is going to be something that's going to be interesting to hear about.
I'll be very intrigued to hear what happens with the venue transfer situation.
And I think, honestly, they have a decent shot at getting it flipped because of that. And the reason I do is because I think that you've got it happened in the same county where the crime occurred that was highly publicized. You've got, I mean, you already had the DA was disqualified. They bring in the Attorney General. You've got that $27 million settlement that comes out during jury selection. The jurors were not sequestered.
No.
And so I just think you've got a lot of opportunity here to have problems with the jury panel, which a lot of people don't understand. We as trial lawyers do, that who ends up in that jury box is probably the most important part of your case. Because,
absolutely. It's the most critical part of your case. Because these are the people that are deciding based on the evidence you get them what the outcome is going to be. And you want them to actually do what they're supposed to do, which is sit there, listen to the evidence, and make the best decision about the evidence and on the instructions that the judge gives them in order to preserve the trial outcome. Because if they don't, if they deviate from those instructions, not only is justice not being done, but then you have to redo the whole trial potentially. So it's a waste of time, money, and resources. And not to mention, especially for friends and families of a victim who has suffered, they have to suffer all over again. And so you want it done right the first time. And also, I mean, the whole reason we have jury selection is to ferry out biases and prejudices. If you end up with someone who's got a predisposition to something that they're not going to let go of, and they end up on that panel and then they hear things that are happening outside in the world in the trial of public opinion, well, if they already have made up their mind, then you're not going to be able to convince them anyways. Well, and it's critical, too, to note that, so here's the thing, at the risk of sounding trite, it's true in influencers and blogging, and it's true for trial lawyers. You convince a few people, whether it's a few people on Instagram to go to, support your brand and carry your brand message and support you, or whether it's true for the trial lawyer, you convince one or two people in the jury pool, and those two people become the leaders in that jury pool. They will go to war for you during the deliberations and be so supportive and vocal and explaining, well, we should do it this way because A, B, C, D, E, F, G. And so they are really there to push what you are saying, because at the end of the day, you need to have at least one or two people on that pool who are going to support your position that you've been arguing, and they're the ones that are going to carry it home for you.
Well, and studies show there's leaders and followers in a jury pool, and so those leaders you're talking about, they usually can get those followers to just kind of come along during that, so it's important to pick those out. One topic I won't spend too much time on, but the California Representative Maxine Waters made some comments that garnered a lot of attention, made some people think that it may allow for some potential appellate grounds. She basically was quoted and somewhat misquoted as saying, we need to get more confrontational if Chauvin is found not guilty. Honestly, it's a lot of what happened is they took her comments, kind of like a lot of President Trump's comments on the Capitol Hill riot, debacle. They took them out of context.
I was about to say, I don't understand the context that this is being said in.
She attended a protest in Minneapolis.
Okay.
She was talking about, we want a guilty verdict, we want a guilty verdict. When she was asked what protesters should do, she said, well, we've got to stay on the street, we've got to get more active, we've got to get more confrontational. We've got to make sure that they know we mean business.
What? Okay.
Well,
I don't know what that means.
Well, and the right-wing commentary about it, the extreme people that got really excited and upset about this took it to mean that she's inciting riots. There was a lot of comparisons to what President Trump said on Capitol Hill and how he got ostracized for saying that, and why isn't she getting ostracized for saying this on the eve of the verdict when the jurors are not sequestered and they can hear these types of things and they're fearful of protests in their city, all these kinds of things. I think they took it out of context. I don't agree with what she said, but I think they took it out of context.
Well, it's absolutely taken out of context because they're not explaining the factual circumstances in which she was making this commentary, and that she didn't explain further what she means. Because I think it's just as likely for her to mean that, okay, we show up outside the courthouse with signs and stand in silent protest and let our numbers and our signs speak for us as we peacefully stand in the street. So I think that's just as reasonable.
I agree with what you're saying. I think Judge Cahill commented, because the defense moved for a mistrial after these comments were made. And his comments were, I'm aware Congressman Waters was talking specifically about this trial and about the unacceptability of anything less than a murder conviction, and this talk about being confrontational. I wish elected officials would stop talking about this case, especially in a manner that is disrespectful to the rule of law and to the judicial branch.
I would agree with Judge Cahill.
I agree. Like, you're a legislator, do your job, make the laws, listen to your constituents. Don't do this during the middle of a trial. especially when the jurors are not sequestered.
We literally have checks and balances for a reason,
Right.
and this is one of those reasons. The executive branch should not be influencing the judicial, and
Yeah.
for any member of the executive branch to do that is highly inappropriate.
Yeah.
No matter what the reason, even if it's for a very good reason, they shouldn't be doing it.
I agree, and especially executive or legislative. I mean, and what's interesting is Cahill did say that when he denied the mistrial, he said that, I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned. I don't know that gets you there. I think the venue issues are a lot more serious, but kind of to wrap this whole thing up, I want to kind of talk about our opinions about everything. I mean, I'll be very blunt with mine. I think that we had a correct outcome in the trial with an unfair trial fundamentally because of the venue issue. I really think that if you're really going to have a fair trial, I understand how big this got thrown across publicity and social media and everything else across the country. I think that the courts in Hennepin County should have made a better effort to at least try to put it in another venue where you're not having the threat of protests and all these types of things happening in the juror's backyard if they come back with a not guilty verdict.
I mean, at the very least, that would lessen the likelihood of a mistrial being granted on appeal. But we'll see. We'll see, and I'm looking forward to seeing what happens in the appellate court.
Yeah, I am too. And I think the biggest thing that I take from this, race was kept largely out of this trial. The actual proceedings themselves, there was not a whole lot of race talked about. Floyd's criminal history, for the most part, was kept out, which I think was the correct decision. Because some people are highly upset because Floyd was not a stand-up guy. He had a lot of troubles in the past. Our judicial system and our law is not set up just to protect every best person in the world. It's set up to protect everyone.
It's a high standard, at least in Texas, to get criminal history in. So, but we'll talk about that another time.
No, for sure. And I think that for me, the big takeaway is I still think we need a lot more police oversight, a lot more training and retraining for mistakes that were made, because Chauvin's history that has been widely talked about of his misconduct before eventually led to this happening. And like we talked about with Tara Avance not too long ago on our show, retraining, I think, is the biggest thing that we need to see come out of something like this to help prevent things like this on a large scale and things like this on a smaller scale from happening in the future.
Absolutely. So.
Well, guys, this is a real heavy episode. We went through and dissected everything. We'd love to hear your questions about anything we talked about today, about how the trial turned out, about what happens next, anything like that, because this is the first time we've gotten to really dissect something that is pretty large. So thank you for listening, and we'll see you again next time.